the role of the company secretary should be able to look beyond and say, yes, we do have pressing matters, but there are other things that may not be pressing today, but 4 months, 1 year down the road, they will be absolutely pressing. So we must make preparations today to make sure that the board does what it must do when they must do it. So the board secretary then would come up with what we call a board work plan, which then sets out in the first quarter we'll do this, in the second quarter we'll do this, so that even if other emergencies arise and they're not able to sort them out in the first quarter meeting, there's a record that we have some things carried forward from the last quarter, which we must look after in our next meeting.
Compliance obligations, sometimes it can be a headache, especially in corporates and companies. But today we want to help you get to a level of understanding on some of the basics that are quite important, especially when it comes to matters supporting compliance requirements under the Companies Act of 2015. Helping us to understand this conversation, or to really unpack this conversation, is CS Malachi Adedeh. Some people may call him Malachi, but that's Malachi Adedeh, and we have had a good laugh before we started, so please join in into this conversation, and straightforward we get into it. Welcome, CS Malachi.
Thank you very much for having me.
It's good to have you here. And the topic of today, the role of CSs in supporting compliance requirements under Companies Act of 2015. It's going to be a great subject because a lot of companies are coming up. Every single day we have them coming up. But before that, when people talk about Malachi, who do you say you are as an introduction in a minute?
As introduction, I think I would say Malachi is a corporate governance practitioner. With the experience of close to 2 decades. It is my bread and butter. It's the only thing I do. Corporate governance.
Excellent. I love that. We have had actually amazing conversations in our previous episodes on matters governance, ESG and the likes, and so it's great to also have you here. Now, moving on, let's first of all talk about CSs, these certified secretaries, and what specific role they play in ensuring companies meet these compliance obligations.
So the certified secretary is a role that plays within the boardroom.
You're right.
But there's also an aspect of it that plays outside the boardroom when you now implement the conversations or the decisions of the board of directors. Now, the board of directors, I think, has been defined, I hope, previously.
Absolutely.
This is the body that plays oversight over an organization.
You're right.
In some circles they are called board of trustees, in some circles they are council members, but a board of directors is that ultimate body that oversees the running of an organization.
You're right.
So whenever they meet and make conversations and make decisions, usually a CS is there to make sure that those decisions, the preparations to those decisions, the making of the decisions themselves, and then the execution of the decisions are well taken care of.
Wow.
So it starts before, during, and after the conversations at the board level.
Okay. Talking about matters compliance, I would want you to help us with just really giving us a few of some of the key compliance requirements introduced by the Companies Act 2015 that impacts companies in Kenya.
So under the Companies Act 2015, one of the major changes that a lot of practitioners have not appreciated is that the role of the company secretary was made now to be an officer of the company. Now, the directors are also officers of the company. So the company secretary is not a board member per se in terms of participating equally in decision making. But if something goes wrong, they are held to accountability at the same level as the directors. So then you must be careful, because if things goes wrong, then the people you will see in court, the people you will see being mentioned in the media, the CS will be there. And you suffer the same ills that then the directors suffer.
As the directors as well.
So as much as we are not part of the decision making,
yes,
it will all be good until when something goes wrong. That's when you realize you're not so off the hook as before.
That then really speaks on the importance of that person.
Absolutely. If you take it for granted, then you're shooting yourself in the foot. Under the old regime, company secretaries were only seen as admin support people, where you're told, come here, take the minutes, sign for me this annual return, and it's done. The act of signing itself now, you're putting yourself in the shoes of a director, because the Companies Act allows certain documents can be signed by the company secretary alone, and they are binding on the company.
Absolutely.
As the administrative officer in that dispensation. So it is something that when one understands, then it helps to short sell yourself, because the role itself has been made important under the Companies Act.
I think you have very well underscored the importance of them. And I wanted to ask, when they sit on these boards, what do they really do to ensure that these particular boards are adhering to the provisions of the Act?
So the traditional role of the company secretary was to sit in the meeting and take minutes.
Yeah, that's what you used to call them, secretary.
It's still there. That's why it's called the company secretary.
Yes.
Now, the role to advise the board on procedural issues. Like the board is going to take decisions, for example, on a contract. There are policies within the company that governs that. If you're in the public sector, you can't just decide and buy and invest. There is a procedure to that. It's the role of the secretary, while at that meeting, while that decision is being made, to ensure that due process has been followed.
You're right. And I see that. That's why they are held responsible now.
Absolutely. Because if you don't, then you didn't do your role as expected as a CS. So then you're responsible.
So would I be right to say that they are the board's eyes on the road so they don't make a wrong turn?
I think they're better than the eyes. I would say they are the conscience.
I love that. Conscience. I love that. That's even deeper now.
Yeah.
Thank you so much for that. Let's move on to the conversation and go a bit deeper in this. And I wanted to ask you about your view on how CSs or Certified Secretaries help mitigate the risk of penalties, because we have heard now you've said they're being held culpable, and we've seen companies, boards, get into serious bad books of getting into penalties, legal issues related to non-compliance with the Companies Act. How do you see the CSS help in mitigating this particular risk?
So I would give an example of what I do in some of the boards I sit in. The board members do not give their day-to-day attention on what must be done throughout the year. Sometimes you are in boards where there are very pressing matters today that the only thing they can focus on are those pressing matters.
You're right.
Now, the role of the company secretary should be able to look beyond and say, yes, we do have pressing matters, but there are other things that may not be pressing today, but 4 months, 1 year down the road, they will be absolutely pressing. So we must make preparations today to make sure that the board does what it must do when they must do it. So the board secretary then would come up with what we call a board work plan, which then sets out in the first quarter, we'll do this. In the second quarter, we'll do this. So that even if other emergencies arise and they're not able to sort them out in the first quarter meeting, there's a record that we have some things carried forward from the last quarter, which we must look after in our next meeting. Time allowing, you can do all of them, or you can set aside a special meeting to specifically clear those carried forward issues. Now, without the ability to look at what must be done, then a lot of things can then fall into the cracks without anyone realizing.
Thank you so much for that. I have seen in some companies, and this is just my mere street way of seeing things, I've seen some companies integrate a management person as a CS, because as you're saying, they are the conscience. I love the conscience. They're the conscience. They need to be sure, because rarely will you see boards meeting as regular. They have their either quarterly or something of that sort kind of meetings. And so I've seen some CSs integrated from management to
especially legal.
Yes.
Legal and CS.
Legal and CS, please. So that's the case. You also observe the same?
So that is it's a very common practice, because the work of the CS is not continuous. You don't come in the morning. If you are an in-house company secretary and that's all you do, and you have one company, the board meets once per quarter. You do minutes for that one meeting, then raise issues out of those, maybe review a policy or two. It is not enough to keep one busy for a whole quarter.
Okay.
So for those who are in-house company secretaries, you might find that then the company finds something else that will keep you busy most of the time, and then allocate a little time for your CS duties. Now, there are pros and cons for that arrangement, because the role of the company secretary, as a company secretary, I am appointed by the board of directors, and I report to the board of directors. When I am management, I report to the chief executive officer. The board oversights the activities of the chief executive officer. So because I'll be reporting to the board and reporting to the CEO, and the CEO is the one who oversees the bulk of my work and sets my salary, there's an inherent conflict of interest where the CS might pay more attention to what the CEO wants as opposed to what the board wants. Now, it's a conflict of interest that when one realizes, then it must be very clear from the outset, so that there's no misunderstanding, so that the CEO then does not get into, does not meddle into the company secretarial affairs, whereas the CS also still remaining respectful and respecting the chain of control within the organization to do the right thing when they should.
Wow.
So it is possible. A lot of people do it, but that conflict of interest need to be well understood, so that one executes their functions independently of each other, because you can't mix them.
Absolutely, and that's a great risk that you have already overseen there. Let's talk about what has been touted as something that needs to be ingrained in the culture of organizations, and that is just matters compliance. And I wanted to ask you, how can CSs help companies develop that culture of compliance beyond just the legal requirements and fostering good governance, so that compliance culture is ingrained in them?
So there's a lot that companies do. Quite a lot. And if you look at a company like Nation Media Group, what we see at the newspapers, there's a lot.
But there's a lot behind the scenes.
There's a lot behind the scenes that happens that requires regulatory approvals. There are people involved. There are factories to be run. There are machines to be bought. All this happens based on certain procedures that have been set by the company. Some, they enforce rules upon themselves. Some, the law imposes rules upon them. Now, the company secretary per se is not a compliance officer. They don't do all the compliance requirements. HR will take care of HR compliance. Legal will take care of all the legal compliance requirements. Other departments will look. Risk department will take care of risk. But at the center of this, there's a CS that makes sure that there are adequate reports coming to the board confirming that what ought to have been done is actually being done. And if there are difficulties in doing what was set out, what are the mitigating factors then that the board can put in place? Because the management executes. They don't set the tone. The tone is set at the top by the board. So, for example, if there are compliance requirements with, for example, CMA or CBK or IRA, which are regulators within this market, then the CS may not be the one doing the compliance, but they must ensure that there's a report from the person responsible coming to the board confirming that compliance was done. So it is the work of the CS to map all the compliance areas and have a tracker that then can be reviewed by the board and confirmations provided that indeed what the company ought to do is being done when they become due.
You're right.
So the role of the CS is not to do, but to follow up and put structures that enables the board to play effective oversight over the compliance program of the organization.
Wow, thank you so much for that insight. Let's talk about going back to the Act. And I wanted to know, there are certain compliance issues in the Act and people must adhere to that. What happens if they don't?
So the most recent addition to, actually this happens across the board. The Companies Act and anti-money laundering and the banking sector, basically the financial sector. There is a global move towards greater transparency on ultimate beneficial ownership. So who is behind these companies? Who is behind this transaction? If there's a transaction with the Kenya Airports Authority, you'd want to know who is actually the person who is going to benefit out of this. So the disclosure on beneficial ownership has been with us since 2020. It's moving, but not as fast as it should have. There are technical challenges to enable that process, but the law is in place. Now, what happens when one does not comply today, though these processes have not been put in place, but not complying is a reason for your company to be closed. Now, when your company is being closed, they will cite non-compliance with the transparency requirements. So there's also a reputational risk to that, because it will be in the public domain that this is why the company is being closed. Now, other than the ultimate risk of the company being closed itself, there are also penalties and fines in monetary values ranging anywhere from 200,000 to 5 million shillings that can be imposed on the officers of the company. Remember, we started by saying that the CS is an officer.
Absolutely.
So you can get the penalty together with the directors, or the directors could hang you and leave you to dry if you didn't advise them that they need to. And then the onus then remains with you as the defaulting officer from compliance under the Companies Act. Now, compliance under the Companies Act is purely the responsibility of the CS.
You're right. Wow.
So if it is not done, that's the CS's fault.
Absolutely.
Yeah.
You know, you have seen it all. Without mentioning names, have you seen a company fold because of this lack of, compliance?
Our regulatory, the Companies Act is being implemented by Business Registration Service, which is a very recent state organization. But even before that, the Registrar of Companies has always been there, and they've always been under the Attorney General's office. Now, in Kenya, the registrar has not enforced her powers to close down companies based on compliance. The registrar has not taken companies to court for lack of compliance. But when I look at this, the sense I get is that
get there or what?
they have not done it before because of capacity issues. And because the moment you take me to court and say I did not comply, I could say that you're singling me out. Why are you not taking everyone? And then that could be a defense for me against the registrar. So it's a capacity issue, the ability to, because the penalties and fines, some of them are based on a conviction. So the move I am seeing now is the registrar is trying to introduce lighter administrative penalties for not filing your returns, for not filing your beneficial ownership, for not filing in time changes in the company and the likes. So we will see increasingly administrative penalties coming in without necessarily being taken to court to be litigated, convicted, then the penalty to and fines to crystallize. So there is the risk, the law provides for it, but I think out of capacity issues, the registrar has not taken companies or officers of the company to court and gotten convictions out of which then penalties could crystallize.
But have you rightfully put, I mean, there's a whole reputational damage risk that is already there for all these corporates and companies, and nobody wants that. So finally, if I may, CS Malachi, the advice to aspiring CSs, seeing the critical role they play, what would you give them as advice? because we know that they're very important, especially matters understanding and implementing what is required in the Companies Act 2015.
So I think I could take 1, 2, or 3 key areas that
would be good. Yes.
An aspiring CS might want to look into. So the first thing is, I don't know if you've seen the Companies Act. It's a beautiful book. It's about this thick. It's the kind of thing that when you sit down to read, it's not for the faint-hearted.
You're right, yeah.
But a good CS would want to know the provisions of the Companies Act in and out. You need to learn the persona, the legal persona that you're going to deal with. Are you dealing with a public limited company? What are the requirements? It's a private company. What are the requirements? You are dealing with a limited liability partnership. That's even a different act altogether. But all these are entities that you need to understand and fully be able, because you cannot advise on what you don't know.
That's true.
I've seen people advise on what they don't know, but as a good CS, you must advise on that which you 100% understand. It's not instant, but people could give themselves time to dig in, and this is it's a personal initiative. No one, it was not done in school. Your employer will not do it for you. It is for that CS to take the initiative to read for understanding.
Okay.
Not just reading. You read it. You have to do the work. Understand the law, what the law provides, because as they say, ignorance is no defense. Advising a client wrongly, because you can do the wrong process correctly. It doesn't help anyone. So understanding the Companies Act or the legal provisions that governs the being of the company you are assisting for compliance is top priority in my list. Now, once you know what you need to do, you need to get into an environment where you are with like-minded professionals. I cannot practice alone. And knowledge changes every day. What was true yesterday might have changed today, and you don't know. So the networks you create as a CS helps you. Sometimes I call fellow practitioners to consult, or to have a sounding boards where you can, yes, I know, but let me check with this my senior or someone who I know is an expert in this area, because he does this kind of work more often than I do. The ability to have someone on speed dial who will not charge you. I'm talking about a network that I can call you and it will not be like, first let me send you a fee note. A lot of our learned friends do not give free advice, but we need a space where people can talk, people can network, people can share knowledge, because the knowledge that can be freely shared is the knowledge that grows. Because if I share with you, you'll share with someone else, then together we become better practitioners. Now, the third advice that I can give to aspiring CSs is integrity. Integrity, you cannot survive in our line of work if you do not have integrity.
Absolutely.
At personal level and at the corporation level. If you are sitting in a board and people are discussing and passing decisions on matters that are not in themselves matters of integrity, you have to speak up.
You're right.
Either speak up for a correction or speak up and walk out of that situation. So integrity is sacrosanct. There's nothing you can say or do to convince a good CS to do otherwise.
Wow.
Now, those 3 points, I think anyone who starts off should be able to make it in this field.
You're right. CS Malachi, thank you so much for your time.
Anytime.
Lovely. I want to just also pick it from there. Integrity, very key as you even consider being a CS plus the others that have been shared. And thank you so much for really tuning in on our conversation on the role of CS in supporting compliance requirements under the Companies Act of 2015. That's it right here on the Weekly Governance Voice. See you next week.